Good morning, everyone, and welcome to the latest session in our think tank series. Today, we're going to be talking about contractors working abroad and the IR35 implications of that, what contractors need to be thinking about, what those in the supply chain need to be thinking about when their contractors are overseas. Clearly, we've discussed on an earlier episode the changes to working practices expected as a result of coronavirus and more working from home. What we didn't really discuss was those lucrative contracts overseas and also where overseas workers have been coming over to work here may have gone home. In a world where international travel has been locked down in a weird way, the world has opened up with more people operating on video calls, more people meeting from wherever they are in the world. And perhaps that's going to continue into the future. So more availability of contractors to be working anywhere in the world. And we need to have a think about what that means for the supply chain, most notably what that means for IR35. Today, as usual, I'm joined with our panel of experts to talk through these things. And I think we should start, guys, with a summary of which entities are required to perform the status determinations, what the responsibilities are on each entity in the chain in a number of different circumstances. So perhaps I could come to each of you, anyone who wants to field it. We've got a number of different working arrangements, I guess, for the supply chain. We've got UK contractor working through a UK PSC, providing services to a wholly overseas client. We've got UK contractor working through a UK PSC, providing services to an overseas client with a UK presence. We've got UK resident contractor providing services through a non-UK PSC to a UK end client, and that's something we've seen more and more of. We've got a UK resident contractor providing services to a non-UK PSC to an overseas client. And then we've got non-UK resident providing services to a UK end client. So we've got 5 different circumstances there. Not expecting you to remember all of them there, but does anyone want to just give a very brief, or as long as you want, précis of the rules and who should be doing status determinations for which of those?
Well, I'll take the first one, Reece, because it's a simple.
Yeah.
If you're a UK PSC and you're working for an overseas end client, and that end client is wholly overseas before the beginning of the tax year, then essentially we fall back to the old rules. It's for the PSC to make the status determination regarding the IR35 status, just the same as if they were working for a company that was subject to the small companies exemption. So we're back to that situation again, where whilst the IR35 reforms, as we like to call them, do not affect you, you still have a responsibility to determine your IR35 status as inside or outside and make the appropriate tax adjustments based on that.
And that wasn't always the case, was it? I mean, a while back, it was looking likely that an overseas client might have to do the status determinations as well. Lots of people panicking that their overseas clients had no idea of IR35, what on earth was going on, and how were they ever going to get a status determination statement out of them. So I guess we can take some acknowledgement there that there's been some recognition of those concerns and the suitable changes made.
But this goes back to, HMRC would love to move the responsibility on to those end clients, but there's practicalities in everything, including legislation. How does a company operating in Argentina understand what its UK tax obligations are if it has no UK presence? It makes absolutely no sense. So I think it's a common sense approach to that change in legislation to put it back to the status quo.
Absolutely. And for your honesty, we'll pass the second one to you as well then, because you've spoken about the UK presence there. UK contractor working through a UK PSC, but providing services to an overseas client who does have a UK presence. Perhaps I can ask you just to explain as well the extent of UK presence and what that means.
Yeah, absolutely. So normally what we would go on here is a concept called permanent establishment, whether if an overseas company has sufficient operations in the UK, they would be said to have a branch or permanent establishment in the UK, and that would make them not wholly outside the UK. So permanent establishment is one of two things. You either got a fixed place, which can make you a permanent establishment, so you have a warehouse or a shop or a factory in the UK, and that would mean that you had a permanent establishment in the UK. Or you have a dependent in the UK, i.e. a person who's not independent of the non-resident company and regularly does business for the company. And that could be a contractor or anyone else that regularly performs business as if they were the company in the UK, hold themselves out to be a representative of the company. So if you have a permanent establishment, then you have a UK nexus, and therefore you're subject to the off-payroll rules just like any other UK company. You will be responsible for doing the status determination.
Just a point to note there, that HMRC's jurisdiction and therefore fixed place of business and permanent establishment sits outside the UK's landmass. So it's not just coast to coast. So if you operate an oil or gas installation or platform, for example, within 12 miles of the coastline of the UK, then obviously you will also be considered to have a permanent establishment, and therefore will be subject to applying the off-payroll rules.
Well, thank you, Bernie. Okay, whilst we're with you then, Bernie, maybe over to you here for UK resident contractor providing services through a non-UK PSC to a UK end client, and then the same question to an overseas client.
Okay, so if the contractor is UK tax resident and delivering the services in the UK, then the location and jurisdiction of their personal service company is irrelevant for the off-payroll rules. So under those circumstances, then the client would still need to make a status determination because they have a presence in the UK. And if they were deemed to be inside IR35, then the fee payer would need to make the relevant deductions. Because the whole point is, it's not where the PSC is located, it's where the individual worker, the contractor, him or herself, is located. Because the person from whom you actually deduct the tax, the NICS, is the person, not the PSC. So the fact that the PSC is outside the UK is irrelevant for those purposes. But if you are a UK tax resident, non-UK PSC, and an overseas client, well, then you will, you will go back to the original rules because the client is, it is not subject to the off-payroll rules because they don't have a UK presence.
Yeah, perfect. Okay, and final point is non-UK resident providing services to a UK end client. Carla, let me come to you for that.
Well, in those circumstances, off-payroll wouldn't apply because the individual providing the services or the company providing the services is not UK resident. As Chris pointed out, there are, however, other issues that you need to consider when you're drafting the contract, because there will be jurisdictional issues, governing law issues. There'll be issues with respect to data protection or data transfers, making sure that if you're dealing with somebody in the EU, that the model clauses are incorporated. So there are contractual issues to consider, but off-payroll would not apply in those circumstances.
Okay, excellent. Go on, Tom.
Well, I was just going to sort of, go a bit deeper into, this concept of offshore company, because something that's, listen, people read newspaper articles and think it's as easy as I just go get an off-the-shelf company in the Maldives and therefore I'm subject to tax in the Maldives and, I fall outside. And of course, it's never as simple as that. A company is a UK resident company if it has management and control in the UK. So if essentially the directors are sitting in the UK and making all the decisions in the UK, it's a UK resident company. We're also back to that permanent establishment. You know, even if you do get yourself an offshore company and you install some offshore directors who allegedly make all the decisions, and you know, you then perform all the work for that company in the UK, you've created a permanent establishment in the UK, which again brings it into UK tax rules. So we're talking about genuine offshore PSCs here, you know, where they are managed and controlled offshore and the work is done offshore. And I don't think people should be fooled into thinking that you can just get an Irish limited company and all of a sudden, you know, be outside the scope of IR35. That's the work of, well, I mean, quite frankly, that's the work of getting you put in jail. That's evasion.
Yeah, Tom, that's a good point. I mean, I think if they're performing significant duties in the UK, then there is a material connection there. But if they're just making occasional business trips, then that would not qualify as a connection. But that's a very good point that you've made.
So taking that further then, and looking at that, there's going to be lots of people who think, HMRC aren't going to bother with me. I'm just setting up a little PSC over here. They're not going to do their investigation. They haven't got the resourcing. How would HMRC approach that situation, Tom? How are they going to overcome kind of cross-jurisdictional requests for information where they don't have powers? What's HMRC's approach there, and how can people make sure they're not falling foul of non-compliance through, I guess, for all intents and purposes, schemes set up overseas?
Well, firstly, when I was at HMRC, if I had a quid for every time I heard the words, "I never thought you'd bother with me," I'd be a very rich man. Probably wouldn't be sitting here at the moment, because the reality is that it's all a risk-based approach. If there is something that is clearly looking like it's non-compliant, it's going to be investigated. And yes, the biggest risks are always going to be taken first. But who's to say, you know, that actually flavour of the month isn't offshore PSCs this month, and therefore you're going to be much more likely to get an investigation than someone who's not operating an offshore PSC. So never think that it's not going to happen to you, because it can and does. I think secondly, you also have to understand HMRC's reach around the world. It's not as simple as saying HMRC are the UK tax authority and therefore, you know, only UK citizens and companies are subject to their powers. Not quite true. Most countries have what are called double taxation agreements, and most double taxation agreements have provisions in there for mutual assistance. That means that HMRC can write to, for instance, the Australian tax authorities and say, we believe that we have a UK tax risk here. Can you use your powers in Australia to find us out X, Y, Z, so we can establish if that risk exists? And very, very, very few countries, keep saying companies, very few countries will not comply with that because it's mutual. They want the same cooperation from the UK. So this is why you go back to a couple of years back where HMRC said, actually, we're now extending the time limits for making assessments on offshore issues. We're extending it to 12 years because actually it's a larger investigation process to investigate offshore matters. And rather than the normal 4-year time limit, we're going to input a 12-year time limit for discovery assessments. That recognises that it's a more complex investigation, but it doesn't put you beyond the reach of them. It's still, the world's small when it comes to tax. Exchange it, you know, who'd have thought Swiss banks would be exchanging information with HMRC 10 years ago? You know, if the Swiss have decided it's time to cooperate with other tax authorities around the world, I think, you know, the writing's on the wall. You know, everyone is going to cooperate.
Yeah, absolutely. Great. Okay, so that gives a helpful guide, I guess, to the responsibilities depending where you sit in the supply chain and where you sit in the world. Moving on, the kind of topic of this conversation is more focused to helping contractors understand their responsibilities where they're deciding to go and work overseas. So perhaps we can take it a little bit away from the supply chain here and think more along the lines of contractors and their responsibilities. Carla, you touched on earlier about contractual obligations that contractors are going to have to operate with. I think there's two considerations there. I mean, if there are more stringent rules placed on contractors where they're operating in a different country, are there any complications there for IR35 and status determination? But secondly, what do contractors need to be looking out for in their contracts for kind of onerous clauses, obligations placed on them where they are thinking about working in a different country?
Well, I'd always point them to the indemnity provisions, their limitations of liability, and more importantly, their insurance provisions to make sure they're adequately insured, particularly if they're working offshore or overseas. So those would be the most important aspects. But from an IR35 perspective, obviously, getting a confirmation of arrangements from the client with respect to supervision, direction, and control, and the other pillars of IR35 would be helpful as well.
Yeah, absolutely. So going into those perhaps indemnities that we could expect to see, obviously data processing is going to be an important one. GDPR still in effect despite Brexit. Chris, perhaps you could perhaps I could come to you on that to explore kind of the responsibilities contractors are going to have to maintain records, to make sure documents remain within the bounds of GDPR.
Yeah, sure. Well, I think it's important that really that they're taking the lead from the client in this instance, as generally it would be their data that they're involved in processing. So it's just making sure that all of their activities comply with the requirements of the client, and that indeed that the necessary agreements are in place for the transfer of data. And on top of that, it's also a question of looking at things like data security, in terms of how you're operating. If you are working in a remote environment, I don't know if you mentioned the Maldives earlier. So, if you're going to be operating, say, in an internet cafe, you need to be very mindful of things like Wi-Fi security and hacking and so forth. So it's just very, very key that you just remain focused on the types of data that you're processing. And of course, if it's personal data, then you need to be really, really careful with what you're doing.
And you're absolutely right. It's going to be led by the client rules, but clearly, as Carla says, the insurance provision of you working overseas is going to be an important one to think about, because as you say, if that data is not, we question mark over whether it stands more chance of being lost or leakage of data from the UK or overseas. I'm not really sure anymore, given the internet, but I think it's something that they need to be seriously thinking about, where you're perhaps moving around the world as well, where you're not in one place, where you're considering working in a few different places, where your contract is taking you into different countries. Need to be thinking about that when you're performing those roles. So I think that's an important position. And when we're thinking about moving around a bit and moving overseas and having short-term contracts in foreign jurisdictions, the contractors also need to be thinking about their tax obligations, both personally and for the PSC that they operate through. Those tax obligations come down to national insurance contributions as well. Tom, Leila, I wonder if I could ask either of you to briefly talk through the tax obligations that contractors need to be thinking about, and whether they need to be thinking about UK taxes through the PSC, despite them operating in different countries, or where their UK residency is important. Can I come to either of you for that?
Your individual tax residency is a matter of fact and not a matter of choice. mean, it can be a matter of choice because you choose to adhere to those rules that make you resident in that country. But by and large, it's not a case of I can opt to be taxed somewhere. You are resident for tax purposes if you meet that country's residency conditions. Now, here in the UK, we have a statutory residency test. It's pretty clear cut in 95% of cases whether you're resident or not resident in the UK. Doesn't necessarily mean that you're not also tax resident somewhere else, though, if you meet their tax residency test, and the tax residency tests are different for each country. And of course, coronavirus put that to the test with people being stuck in countries that perhaps they didn't want to be tax resident in, and perhaps not being able to get back to countries that they did want to be tax resident in. Again, important points there, national insurance and that sort of thing. Clearly, there's a dependency on being eligible to make national insurance contributions and qualifying for your pension in the UK, which is important. So it's very important to know the individual rules for the country, and also what the Double Taxation Convention says, that document I talked about earlier, which sets out how the two countries tax each other or tax people who share a tax residency. Maybe you're entitled to relief for some of the tax you pay in one country against the tax that's due in another country. But it's a complicated subject. And when you start getting into being an itinerant worker around the world, it's something you need to pay very particular attention to. And I definitely would be highly suggesting, as maybe I would, that you get specialist advice on that, because people have been caught out before and it can be very expensive.
Yeah, I think you're absolutely right. I think there's not one size fits all answer to that question, is there? There's different rules in different jurisdictions around the world. There's people traveling to different jurisdictions all the time for different lengths of time based on a different motivation, whether that be that they've got family based there, whether there's just a small contract based there. And as you say, the statutory residence test in the UK takes all of those things into consideration, and countries around the world will have a similar system to check that through there as well. So there is a responsibility there. And again, we're always, it seems, asking contractors to be their own tax advisors and really understand the rules. But I think there is an obligation, unfortunately, on contractors to understand the rules, given that they, whether there's an acknowledgement of it or not, run a business. That understanding of the relevant rules that affect their business and affect themselves is an important one. And I think that's really the purpose of discussions like we're having today, and to try and provide contractors with that knowledge. But there are hundreds of advisors in the UK that will speak to you and give you some brief kind of information and advice for free. You don't need to pay for that, but you do need to be thinking about all of these things where possible, because as Tom says, it's not going to be a case of, well, I was only there for 2 weeks, so HMRC aren't going to catch me. It shouldn't be thought of it like that. It should be, how can you stay as compliant as possible and gain as much information and knowledge as possible. Layla, is there anything you want to add? Well, Bernie first. She's got a hand up.
Sorry.
Very polite.
I just wanted to say, it isn't just about the tax position either. There's also considerations around right to work, because there are plenty of countries that say if you come into our country with a visit visa, that is essentially a visit visa for the purposes of tourism or visiting friends and family. And their definition of what you can do while on a tourist or visit visa is extremely narrow. So you can attend meetings, but you can't physically do any work, and you certainly can't run a business. So, and people have been caught out, particularly, I have to say, in the US, around going into countries on visit visas, but actually conducting work there and being found out conducting work there. So there is a right to work issue, not just a tax position issue as well.
So let's explore that a little bit more then, if you don't mind, in terms of, we've spoken previously about the effects of Brexit on the changes in contract. We've spoken previously about the requirement for sponsorship now in Europe. Perhaps we could break those down into two things and look at contractors working in Europe given that we've seen, I guess, some stalling of European companies hiring UK contractors, given the concerns around Brexit and what that really means. Whether that has long-term impact, I'm not so sure. But right now, I've definitely seen a number of European companies saying, we'll hold off on those UK contractors for now. So what is it that, let's open up the scope of the discussion and say, what is it that those end clients need to be thinking about to prepare themselves for, or get used to the changes of Brexit, but also what should contractors be thinking about where they're working in Europe now? I think nothing's substantially changed overseas, so I think we can leave that where it is for now, but let's look a little bit closer at Europe, if you don't mind, Bernie.
Yeah, well, obviously, you know, any individuals who are UK nationals looking to work within Europe now are subject to those individual country laws around getting visas to work there. You know, there is no dispensation anymore because, of course, the UK is not part of the EU, so there is no freedom of movement. And of course, every country has its own obligations and regulations with regards to how you get the visa. Some of it is led by the individual themselves. So, you know, providing the individual has, for example, a job offer and proof of a certain amount of funds, and they do a language test, then they will be given a visa. Other places, the visa process is dictated and managed by the employer. So the employer has to do everything and fill everything in. So I think it is more difficult to hire UK, and of course, particularly difficult in the sense of a contractor, if they are a genuine contractor, because they're not looking for a permanent role, of course. So how are they going to get the relevant documentation to be able to get a visa for that country if it is not a permanent offer of employment, for example? So I think there are, you know, particular complications around any form of contracting or temporary work. There are certain, you know, there are management companies in most European countries who will facilitate and support with either, you know, employing in country or supporting with a self-employment vehicle in country within certain European countries, but a lot of them can't facilitate visas. So again, you know, that's not necessarily going to work the UK, but, you know, some of them can. But management companies tend to be very expensive. You know, you're talking from a contractor's point of view, talking anywhere between 5 and 8% of their pay rate will be paid to the management company. And if they are sponsoring a visa on top of that, it's considerably more. So the upfront fees can run into a couple of thousand euros. So, you know, it's not cheap to do. And if it's a short contract, it's not worth you doing it. So then you kind of have to hope that you're in a situation that you can do the work remotely and you don't have to be on client site every day. When you're looking at it the other way round and you're talking about UK companies and how they get talent that they need, well, the UK has implemented an employer-led kind of visa situation, or rather it always had, but now it extends to EU nationals as well. So companies can't just hire individuals who are not UK nationals. They have to have a sponsorship license, and they have to undergo certain they have to apply for that license, and they have to fulfill certain criteria to even get that license to be able to sponsor individuals to come into the UK. So the process is a little bit more onerous on the employer. It's certainly not cheap for the employer, and actually not cheap for the individual as well, because they also have to pay for their own visas. So you know, it's costly for both sides, and I think it will have an effect. But there are plenty of companies throughout Europe and in the UK, the really large ones, they are used to dealing with employing people from all over the world, and therefore they have all of those processes set up, and for them it's just a cost of doing business because they want access to that wider talent pool. But for many smaller businesses, I think it will be just a step too far. It will be too challenging.
I was going to ask you that. I mean, obviously, yeah, we'd expect big businesses with big compliance functions to understand all of that. But it's amazing how it's just expected that small companies are to grapple with new changes like this overnight, new costs, and just get on with it. I struggle to see how companies are going to be able to do that without taking external advice. I don't. It's amazing, really.
Yeah, I mean, there is a huge burden on businesses in all aspects of running their companies, and now immigration, which was much freer, and you had the whole of the European Union to look at. Now and use, you now can't. But that, having said that, you could argue that it's not like Brexit was quick. I mean,
yeah, that's true.
We knew it was coming. And if companies had a need for, migrant talent, then it is their obligation to find out what that might be. I'm not saying it's right or it's fair, but I think the difficulty is that ultimately, some of these policy decisions aren't based on the small companies who are going to be disproportionately negatively affected, because it's not those companies that contribute the most to the country's GDP.
Yeah,
places as that.
Very true. And I think perhaps there's also an observation that those companies that don't contribute to the GDP will be hiring in the UK, so or should be, and that will force more work in the UK. So it's very punitive to those small companies, isn't it? Difficult and restrictive. Good. Okay. Well, I think that covers things pretty extensively, guys. Does anyone else want to raise any other points that they have in the discussion?
I was just going to add to Bernie's comment there in terms of contractors who are in the UK as sponsored migrants, that if they end up working remotely overseas for what is considered a long period of time, they might need to be very careful about invalidating that sponsorship. So they need to tread, very carefully in that area. I mean, it's fine for short-term business trips that the end client is, sending them off to Paris for a 2-day meeting. But if they're going to be working overseas for a long period of time as a sponsored migrant, then they may jeopardize their position in the UK in terms of living and working back in the UK. So just something to be very careful of.
Yeah, good point. Okay, great. All right, well, I think we'll leave it there for today. Thank you all for your contributions, as always. Very insightful, and I'm sure contractors are going to find that both frustrating and helpful in equal measure, unfortunately. But as before, thank you all for your time, and we will see you next Thursday for our next session.